Hello, everybody. Thank you so much for tuning in to the Debt Hotline. My name is Hannah Locklear. I am a part of Team Solo, and we are the hosts of the Debt Hotline. Every week, we like to answer people's questions about debt and help people find resolutions to debt and help them negotiate settlements or respond to debt lawsuits if they've been sued. So if you have any questions about debt, you can always give the Debt Hotline a call. Our phone number is 801-613-8181. And like I said, we collect questions throughout the week and we respond to questions twice a week. And so, yes, we are excited for the topic for the day, which is what to expect if your debt case goes to court. And we actually have a seasoned attorney joining for tonight. And super excited to have Yale Levy join. So Yale is actually a member of Team Solo, but in his past, he was a debt collection attorney and actually founded his own debt collection law firm. So he has a lot of experience on both sides of the litigation spectrum of what it's like to navigate a debt collection lawsuit. And we're super excited to have him share his expertise and tell us a little bit more about what to expect if your debt does go to court and maybe other ways that you can prepare for court. Yale, thank you so much for joining. Do you want to take a moment to tell us about yourself?
Yeah, thank you, Hannah, for the nice introduction. Again, my name is Yale Levy. I'm based in Ohio. I was a collection attorney, as Hannah said, for 25 years. I had an office that represented creditors and debt buyers and collection agencies from around the country in Ohio, Indiana, Kentucky, Virginia, and Maryland. We use the legal process, i.e. the court system, to collect debts that people refuse to voluntarily pay. And that means we filed lawsuits against them, like many of you might have received. And we use the legal process to recover that money, either through voluntary payments from consumers when they got sued, or for some unfortunate people, we use bank garnishments and bank attachments and wage garnishments to take money from people that did not pay once we obtained judgment. So again, I've done this for a very long time, over 20 years. Started from 3 people. We had about 110 people when I started my practice, and was then hired by Solo to help them in the client development stage. My duties at Solo is to get creditors and law firms to engage in settlement offers that they receive on Solo Settle, which is one of the products that Solo has. It allows consumers to initiate settlement offers with their debt collector, and we send them the debt collector, and we hope the debt collector will respond to the offer either by making a counter offer or by accepting. And that's part of my job, is to get people to engage with the consumer offers that they receive.
Love it. And so you have, about 20 years of experience as a debt collection attorney on that other side. And now you're on Team Solo and you're trying to bridge the gap between creditors and collectors and consumers to try to make settlement more frictionless, more possible, and easier to navigate especially for consumers, but for everyone involved, right?
Exactly. We are now totally impartial. It is a win-win. When a consumer makes an offer and a creditor accepts that offer, both parties win, because we've done lots of research on this, Hannah, and an ideal settlement as fast as possible is what everybody wants. So we try to help that process out by getting rid of phone tag, hold time, emotions, and allowing people to use an online portal that we have to a platform to allow them to communicate digitally, avoiding hold times, avoiding phone tag, avoiding emotions, and just dealing with dollars and cents and trying to get cases settled, which is what everybody wants.
Yeah, I think in most cases, the ideal outcome would be to settle the debt, right? To
Correct.
just pay off, even if you can pay off like a portion of it, but to settle it so that you're not having to worry about it coming back up in the future. So yeah, I love that. And I think for tonight's topic, again, we're going to be discussing what to expect if your debt case goes to court. I was hoping maybe we could ask you a few questions to kind of speak to that topic, Yale, since you have so much expertise in that topic. So my first question for you is, what can a consumer expect, like as far as the timeline of a typical debt collection lawsuit goes? What does it usually look like?
Okay, so that's a great question, Hannah, and I think it'll be very educational for everybody on this debt hotline tonight to learn about. So again, creditors have tried to send letters, make phone calls to consumers to have them voluntarily pay their debts. Some people do pay their debts when the creditor reaches out to them. And when I say creditor, I mean the issuer of the credit card. So it could be JP Morgan Chase, it could be Capital One, it could be Discover, it could be Synchrony Bank. Those are the major ones out there, but there are hundreds of different issuers that issue credit cards, even like Navy Federal Credit Union or the different credit unions in your states all have collection departments internally to try to get cases settled. Unfortunately, many consumers don't want to communicate with the creditor, so the creditor then hires a third party, typically a collection agency, to try to do a second talk off, which would be calling and sending letters to the consumer from a third party, from the collection agency, asking the consumer to voluntarily pay or settle the amount of debt that they owe. Usually that goes between 1 and 3 up to 5 different collection agencies might be contacting the consumer, asking them to pay the debt, either by verbally talking to them on the phone or via mail. If that doesn't happen and the collection agency can't voluntarily recover the money, the creditor then takes those accounts back and makes a decision to either send it to a law firm to sue, sell it to a debt buyer for them to try to do it, or to close it and just keep trying internally themselves. Again, my expertise was the law firm. So some accounts based on different matrices and algorithms that the creditor has qualify for suit, because suit is an expensive process. So by going through the suit stage, the cost of poker has now gone up, because now the creditor has to pony up and pay some court costs to the court to file the suit. So before that happens, the law firm would send a demand letter to the consumer, maybe 2 or 3, and make some phone calls to the consumer, trying to get them to voluntarily pay the law firm instead of the collection agency or the creditor. Unfortunately, many people do not respond to those attempts, and leaves the law firm no other option but to file a lawsuit against the consumer. Again, there's a fee to file the lawsuit, there's legal time involved. So we use our best efforts to try to find those consumers that we think are most likely to pay. Once a lawsuit is filed, it takes a life of its own. The consumer, also known as the defendant, has to file an answer to that complaint or answer to the summons. Usually a summons is attached to the complaint. The summons basically tells you how long you have to respond to the complaint, but the complaint is a demand for payment in a legal format, and you typically have between 14 to 30 days to respond on it. Every state has a different time period to do that response. Yes, you can request an extension of time to answer a summons. That is called a motion for an extension of time. If you go to solosuit.com, we do have an AI engine that helps people draft motions. And you could say, can you draft me a motion for an extension of time to file an answer to a complaint or summons? You can do that. I believe the fee is $10, just to be completely transparent here. Or you go online and try to find it yourself. But for all of you on this call today, what you need to know is you got to respond to the summons with an answer or a motion to extend time to file an answer at a later date. If you do not file an answer, most likely you will get a default judgment taken against you. Not all the time, but the majority of the time. if you go to solosuit.com, Hannah has written some beautiful blogs about how to file an answer, how to respond to a complaint, what affirmative defenses means. And that is some legal jargon. That means, do you have a defense to that complaint? Like it's outside the statute of limitations, fraud, etc. So you go to the blogs that SoloSuit provides to consumers free of charge, and you could look into seeing how to answer that complaint. But you need to answer every single allegation contained in that complaint, as well as any affirmative defenses that you might have. Now, if this is all confusing to you, you could always go look for an attorney to try to help you. You could also read Hannah's blogs. They are fantastic. She did a really good job trying to boil it down to make it easy for people to do self-help. And then you could use SoloSuit, which is a program that Solo has, or a product that Solo has, which is like a legal Zoom product that allows you to answer questions. And based on your answers to your questions, it makes an answer for you. You could also go to many courts have free clinics that also help people that are pro se, meaning representing themselves, to file those answers. So that's all important things to know. Once you file the answer, usually a scheduling order comes out where it says, hey, there's these deadlines to file motions, and that there will be a trial date, usually 6 months to a year from the date the answer is filed. Now, sometimes those will be some courts and some states, the trial date could be 30 days out. So what you need to do, and I know this could be foreign to many of you, is you need to open your mail and read it and understand what they're saying. Because if you don't do that, you're going to end up losing. So that is a very important footnote that everybody on this call needs to be reminded of. So again, the trick to a case is communication. So with all this legal stuff I just talked about, any time in the spectrum or during the duration of the suit, you are able to contact the collector or the law firm or the attorney and try to settle the case. You could do that in many different ways. One way to do that is by picking up the phone and talking to somebody. Another way to do that is taking some money out of your pocket, hiring an attorney to help you who knows what they're doing. Another way is try legal aid. Unfortunately, legal aids are pretty overwhelmed with criminal cases and domestic violence cases, that they do have 1 or 2 people dedicated to debt collections, but it's probably not enough to handle the volume of people that come to see them. Or you could use our product from Solo called Solo Settle, which allows you to digitally make a settlement offer to the collection law firm or the collector and try to settle it yourself over time. So there's many options there. If you do not settle the case, at the end of the process, there will be a trial. Again, I went through high school, I went to 4 years of undergrad and then 3 years of law school to understand how to do a trial. Many people can do it on their own. It takes a lot of research. It's a very foreign situation for many people. The courthouse is not always very inviting, but again, it is open to the public, and you could go there and try to defend yourself. Again, for many people who they do actually owe the money, a settlement of 80% or more or less, a little bit more, is probably a win, because that way interest stops usually, and you could try to get the case settled. So that is basically the litigation process. I apologize for talking 10 minutes straight.
No, that's awesome. I think it's super helpful to know the whole process and to know that even if you have been sued, like it's not too late to negotiate and settle the debt. And in fact, if you file a response to your lawsuit, that could actually get you some leverage to negotiate outside of the court setting and then settle the debt before your court date. You can avoid the whole intimidating trial process altogether by settling before court. So I think that's a really good point. And like Yale said, we have a tool at Solo called Solo Settle, that can help you connect you with creditors and collectors and law firms alike and help you negotiate and settle your debts before going to court. You don't have to be sued to use the tool, but if you have been sued, it's still a really great tool to help you negotiate and navigate that legal process, make sure that your rights are protected, and make sure that once you find an agreement with the creditor or collector, that the agreement is documented and your payment goes through safely to them. So great response to that question, Yale. I did have a follow-up question. If you could maybe briefly explain what happens during hearings and trials for debt collection lawsuits. I think that's a big question that solo users have. If they have a court date coming up, like what should they expect to happen during the hearing, especially if they haven't negotiated and settled the case yet?
Right. So if you actually go to trial, you need to be ready to answer under oath questions asked by the attorney of you, and you have the ability to ask the witness for the plaintiff questions as well. So what you need to do is answer truthfully, because you're under oath, and be honest with your answers to the questions. Now, you got to be very careful to understand each question that is asked of you, because you don't want to misrepresent or misstate the answer to the question. There will be a judge sitting on a bench, elevated typically, that looks down and keeps the process moving. There's also somebody called a bailiff who is there to keep order in the courtroom. And then there's another person, another court official called a stenographer. Typically, sometimes they use a tape machine, but it takes down a recording of all the testimony that is provided during the trial. So all those things happened. You have the ability to do an opening statement. The plaintiff has an ability to do an opening statement. Then questions are asked by both parties, for the plaintiff and the defendant. And then there is closing statements, which could be used to summarize what the testimony was at that trial. Again, there are many, many resources on the internet available to you about how to do a trial, what questions to ask on a debt collection case. Typically for a defendant, they'll be asking about who owns the debt, what was the foundation for record keeping for the amount, and how did they come up with the amount owed. The plaintiff's going to ask the consumer or the defendant questions such as, did you open the credit card? Did you use the credit card? Did you make payments on the credit card? Did you receive these statements? Did you receive this last statement? Is this balance due and owing? And then you under oath have to answer to those questions. It is not a very fun process. For some people, it's very intimidating to be questioned under oath in a courtroom. Sometimes you're the only one in the courtroom. Other times there could be 20, 30 people in the courtroom all listening to your responses. So all those things are happening at the same time. It's something that you need to maybe prepare ahead of time for and get your ducks in the row. If you have any exhibits that you want to introduce into evidence to back up your defenses, you need to make multiple copies of those so that you can provide one to the judge, one to the plaintiff, and one to the stenographer, so that you have those exhibits ready to go.
Love it. That is a great, I think, response. And I think most people feel very intimidated when they think about going to court, because they picture kind of like a trial movie setting where there's a judge and maybe the judge and all the witnesses are yelling and there's drama and the attorneys are screaming and it's just this big legal battle, right? I don't think that's typically how it usually works for a debt collection lawsuit. In many cases, if they can't figure out a resolution right there on the spot, the judge may even give the plaintiff and the defendant some time to negotiate and settle, or the judge will just make a ruling, right? So it can be a very intimidating process, but again, one way to avoid having to go to court and navigate all that is by settling before your court date. And Yale, would you agree? We've got some people asking questions here on the live chat. Would you say that most attorneys would rather settle before going to court. Wouldn't it save them time and money to be able to settle outside of the court process?
My gosh, Hannah, it's like you're an attorney or something. Yes. Um, Everybody wants to settle because they don't want to go to court either. Sometimes it's far away from their office. Sometimes it takes 2 to 3 hours to get through the court process. So everybody does want to settle. Now, some people do want 100%. That's rare, but it does happen. Most people do settle somewhere between 75 and 90% of the balance owed. Again, for you consumers, that is always a good deal, because if you don't settle and you end up losing the case, there's going to be additional court costs if they start doing garnishments and bank attachments, and you lose control over when your payments are due. So if you settle, it's great because you can have some input into how much and when the payments are made. If you don't do that and a judgment is taken against you and they find what bank you bank at, or they find where you are employed at, then they could do something called a wage garnishment. And now you have no say in how much is taken from your paycheck and how often. It's usually once a month. In Ohio, for instance, it's 25% of your take-home pay. In other states, that could be different. I am only licensed in Ohio. I don't know about other state laws. And a bank attachment is the same thing. There's a statutory exemption amount. If they find your bank account, they could take almost all your money except for anything that's exempt, like Social Security, veterans benefits, disability, unemployment. And then there's a statutory amount of a couple $100. Anything over that could be taken from you and used to pay off the judgment. There's also something called a judgment lien, which means that they place a judgment on your house, on your property if you own a home, and then when you try to sell it, you can't sell it without actually paying off that lien first. So again, that's why settling a debt with creditors and collectors is advantageous to the consumer, because you now have control over how much, what the monthly payment will be, and when the payment will be coming out. So to me, that's a win.
Yeah, for sure. I think settling, even if you end up settling for the full amount, like you say, I'm going to set up a payment plan and just pay off the debt. That could be maybe a better outcome than just ignoring a lawsuit, getting your wages garnished. You end up having to pay post-judgment interest. You could pay thousands more than you originally owed. And you, like you said, Yael, you don't have control over when those payments come out of your bank account. So setting up that payment plan, even if you end up paying the full amount, which in many cases, you could actually negotiate it down to where you're settling for a percentage of the original amount that you owed. That's obviously going to be a better outcome than having to owe extra money on interest and then not having control over when that money comes out.
Yeah, the lack of control to me is the biggest negative. Real quick, to answer Stephen's question, I would recommend.
Before you answer it, can we read it out loud just so for all of our listeners so they know what the question says?
Stephen said, I'm in Mass and the only source of income is Social Security. My trial date is 9/23. I did put in my answer that Social Security was my only source of income. Should I call the attorney or just wait for the trial? Again, Stephen, communication is the golden rule in everything, in marriage, in business, and in litigation. I would suggest you reach out to opposing counsel, tell them that all you have is Social Security, that you don't have any other assets, if that's true, and maybe he'll let you off or give you some kind of low settlement to get the case resolved. But I would reach out to him ahead of time. I would hate for you to go down to court, wait around for nothing. So I would always recommend communication. You could do it through Solo Settle, or you could just call the attorney them directly and try to get that case settled. For Mr. Mann's Brickhouse Films, can they force the sale of your property, or would it just be a lien on your property? Well, yes, they can force a sale. It is a very unusual process. It's a very unusual for them to do that because it's very expensive to do a foreclosure. So typically they just let the lien sit on the property and wait for you to try to sell it or refinance the house, and that's when they get paid. But again, I am not licensed in your state, Mr. Mann, and I'm just giving you hypothetical responses to these questions. Liznette says, how likely is it for them to garnish wages due to a personal loan debt? Is that likely if you end up settling? So, Liznette, yes, if they get judgment against you and they find your place of employment and you have not reached a settlement with them, there is a good chance that they will try to garnish your wages. Again, I don't know what state you're in. I don't know if your state has wage garnishments, but if they do, that would be a very viable possibility.
Yeah, so you definitely don't want to ignore the opportunity to settle. Let's see. So, Yale, we've got some questions that were submitted to the debt hotline. Again, our number is 801-613-8181. For anyone listening who has questions about debt, you can submit a question there via voicemail. We have some great voicemails that came in with questions prior to prior to us going live tonight. I wanted to address some of those questions with you, Yale, if that's all right. I'm going to go ahead and share my screen. For everybody listening live, let us know if there are any audio issues. We definitely want everyone to be able to hear the questions coming through. So I'm going to go ahead and share my screen right now.
Here's my question. I'm on SSI. That's the only thing I get deposited into my bank. Credit card company says they're going to freeze my account and take my money. Are they allowed to do that since I'm only on SSI? I don't have any other assets whatsoever. I rent. I basically live on the SSI only.
So that's a great question. Again, they can try to hold up your Social Security, your SSI payments by filing a bank attachment. If they do that, you need to go down to the courthouse and file an objection to the garnishment saying that is exempt property, assuming in your state that SSI is exempt, which I assume it's exempt in most states. But again, I cannot guarantee that. I would go down if they do garnish you or do a bank attachment. I would go down and object to that, saying it is exempt assets. What I would do proactively, if it was me and you were my friend, I would say, call the creditor, tell them, or the law firm, tell them I only receive Social Security, SSI, it is exempt. I have no other income other than that. Do not garnish me because I'm telling you that this is a true statement and that will cause undue hardship on me. And that might help maybe avoid having to go down to court and dealing with getting your money back, because I'm assuming you need that money to live on.
But it's true, Yale, that in most states, if your only income is Social Security, that it will probably be protected from wage garnishment.
Correct. Well, bank attachment.
Bank attachment, but not wage garnishment?
Well, it's not a wage. It just goes into the account. So
okay.
It's just a bank attachment.
Gotcha. Okay.
But again, to whoever that was, I hope she's listening. Again, open your mail because you'll get notice of the bank attachment, and hopefully you could contact them early enough and file your exemption or objection saying that this is SSI and it's not attachable.
Awesome. That's a very common question we got. In fact, a lot of our live listeners tonight are asking about Social Security income and how that works for them. So thank you, Yale. Okay, we've got another question. I'll go ahead and share my screen live now. Just give me one moment.
Yes, hello. My questions are, first, I guess I have to, I want to thank you guys for doing this. You're empowering us small guys against these huge corporations. The debt I owe is approximately $10,500. Who is contacting me about the debt is an attorney for Discover Bank by the name of, I believe is it Kent Bailey or no, Rostrom. Yeah, Kent Bailey, Ross and Sturm. And yes, I guess I am getting sued, but I answered to complaint. And then it spit back my question is, so I did the answer to complaint, the kind of following the guidelines online there, which was great. But then we got order assigning to arbiter. So this is what we got from the Superior Court, State of Arizona, in the county of Yavapai. It says with the case number and order assigning to arbiter. So just trying to figure out what this step is, and I'm assuming it's like a third party, an alternative dispute resolution coordinator. So I'm just trying to figure out, and would like to know, like, what is this step? Is this where we work on settling a negotiation? Obviously, I'm not going to pay $10,000. I'll settle, or should I keep fighting it, not to pay anything? I mean, what are my options here at this step, and kind of the time frame? And do I meet with someone in person? Do I go to a different court? I mean, how does this step work? That's basically my question. Thank you.
Well, great. So ADR, or alternative dispute resolution, is an in-court settlement process where the court provides a safe place for the parties to talk to each other and try to settle the case. Now, we deal with Rostrom a lot here at Solo. They really do respond pretty quickly to Solo settled offers. So if you don't want to go to court and you want to try to get this done frictionlessly without having to take off time from your job and go down to the courthouse, you could use Solo Settle to try to make a digital offer to settle the account. Again, they're not going to take 50 cents on the dollar, but they might take 75 or 80 cents on the dollar to get it settled over time. And you could do monthly payments for 12 to 24 months. I think that would be a very viable offer on a $10,500 debt. If you would rather go down to court and see somebody face to face, that works as well too. Again, I'm not trying to dissuade you from not going to the arbitration, but if it was me, I would try to do it either over the phone or via Solo Settle before the arbitration date, and try to get the case settled before then to save you some time and money, because you have to go down to court and you got to park downtown and wait and miss some work. But if you want to go down to do the ADR, I think that would be great. You could see somebody face to face. You can explain your situation, and there will be a neutral third party in the middle where you tell them what you want, and then they'll reiterate it to the attorney. The attorney then will come back with what they want, and then the arbitrator will tell you what the attorney said, and they'll go back and forth. Like by playing telephone. So I think you're in a good spot. You have lots of options there. I like Solo Settle because I'm a young guy and I like using digital. So by doing it online, it goes a little bit faster. But if you want to go down to court and do it face to face, that's your right. And that's why the court has it, to help people try to get these cases resolved. So either way you go, it's going to be a win-win. But I think the trick is to have realistic expectations about how much you get off. I don't think it's going to be 50% or 60%. It'll probably be something north of that, but maybe you'll be able to get some time, like 12, 24, 36 months to pay it over. So instead of paying it all at one time, you can pay it over 2 to 3 years.
Perfect. Okay, let's see. We've got a couple more questions, Yale, if you've got a few more minutes.
Yeah, let's go.
All right. So our next question comes from Greg. I'm going to go ahead and play his question.
Hello there. Hi. My name is Greg. I actually am being sued by a collector who bought a debt from Capital One. Um, Basically, I got sick, unable to work, and I basically was applying for disability in the process of me not being able to work. Um, they sued me, and actually went. It hasn't gone to court, but they court dates have been set. Just recently, the collector, I don't know, by way of whatever, they must have found out either they didn't have all the information or they found out I'm on disability now. And so now they sent me paperwork saying they want to dismiss the case, but they want to dismiss it without prejudice. And I didn't like the fact that they wanted to dismiss it without prejudice. So I sent back and said, why don't you dismiss this with prejudice? And I haven't gotten any response. I'm just wondering to understand. They want me to sign this thing they sent me that says dismissal without prejudice. Should I sign it, send that back, or should I just wait to see if I get a response from them? I know this is kind of lengthy, but the court date is not scheduled until next month in October, and then I had two Capital Ones. They have both of them. The other one is scheduled for in November. But thank you for your time. I hope I can get at least an answer. I see that you have a debt I'll be watching called YouTube today. So thank you for your time, and I hope you have a great one. Bye-bye.
Boy, what a great question. I think I'll go back to my standard response here. Communication is your best friend. So I would call the attorney that sent you that notice of dismissal without prejudice and try to convince them to make it with prejudice. Um, Again, in most states, and I don't know what state you're in, you can only dismiss twice. So if they dismiss a second time, it's always with prejudice. But the first time is without prejudice, giving them a second bite of the apple. Since you are on disability and they're coming to you, I would try to finesse it, call them, communicate with them, and try to see if you can get a dismissal with prejudice out of them. Again, you thinking about it is great, but if you don't communicate that to the lawyer that's sending you that communication, it's never going to happen because they won't know why they need to dismiss it with prejudice. So if it was me, I would call the attorney, talk to them, and see if you can convince them to dismiss it with prejudice. That is your best case scenario. Again, the second best case scenario would be a dismissal without prejudice. That means there is a chance that they will turn around and file a suit against you again. It's interesting that they are doing this on their own accord. So maybe there's a problem with the case, or maybe it's your disability. I don't know, but I think you're in a good position. I would take a second bite at the apple and call them and try to talk about doing it with prejudice and see why they won't.
Love it. Yeah, I mean, my guess is the reason that they're trying to do it without prejudice is because they're hoping that someday Greg will no longer be on disability and will maybe have some sort of an income. Then they can refile the case, right? That would make sense to me, but maybe there's something else going on with the case too, like you mentioned.
Right.
Cool. All right. Well, I think we've got time for maybe one more question. We've got another one from Stacy that I can play here. So let me go ahead and queue up her question.
Hi, my name is Stacy, and I actually have a few questions. One is, if my debt was sold to a creditor and I was never notified of that debt being sold, can they still sue me? So I am actually being sued and my debt amount is $6,000. I did call the original owner of the debt and let them know that I had lost my job and I wanted to go ahead and work out a payment plan with them. They couldn't go any lower than what I could do at that time. Anyway, so that was one of the questions. My other question is, once the judge sees it, let's say they, I don't know what happens next, but could you negotiate the amount of the debt when it goes into, when you're being sued? That's my question. Can you negotiate the amount of the debt to settle it? I think those are my only two questions. This particular debt, yes, like I said, I had contacted the creditor, the original creditor, kept them up to date with what was going on with my financial situation, and then I couldn't pay it anymore because I had lost my job. So yeah, thank you.
Yeah, so she had a two-part question. The first part is, yes, debts can be sold. So if the original creditor decided that they no longer want to keep the debt on their books, they are able to sell that to somebody called a debt buyer, which is a person that buys debts from creditors and then sues them themselves. So yes, that is an option. And to your second part, yes, I recommend you communicate with the debt buyer that has your account now or their lawyer and try to settle the case. Most debt buyers and many creditors always will entertain settlement offers from consumers. Again, the days of 20 and 30% are few and far between, but it does happen occasionally. I see many debts settling in the 75 to 85% range. But again, we do have the whole gambit. Some accounts do settle for 100% on the dollar. Other accounts maybe settle for 20 or 15% on the dollar. It just depends on the creditor, the law firm, your specific circumstances. So all those different factors do play a very meaningful role in how much the lawyer, the collector, the creditor will accept in exchange for resolving the account. But the only way you get there is by communicating with the collector that has the account. And again, one more time, there's many ways to communicate. You could pick up the phone and call them. You could hire an attorney to help you represent yourself. You could go to legal aid and see if they have capacity to help you with your case. Or you could use our product, Solo Settle, which is a digital collection platform that allows consumers to initiate settlement offers with their creditors to try to get cases settled. Again, in our opinion and my opinion, a settlement is a win-win for everybody. It provides finality and it provides guarantees. So again, as long as you can make the payments, to do a settlement, make a budget, make sure you agree to something that you can afford to pay. Don't be all, up in the clouds thinking, oh, I could pay $800 a month if my disposable income after all my bills only $250. That ain't going to work. You got to get a payment plan that can fit in your budget every single month, month in, month out, until the debt is paid.
I love it. And just to clarify too, with Solo Settle, basically all you have to do is get on the portal, respond to some questions about your case, our software will actually kind of help you walk through and break down your income and the amount of money that you have versus the expenses your monthly expenses and whatnot. And it'll give you a few options of different offers that you could make and probably help you weigh your chances of getting those offers accepted. And then from there, you can select what number you want to send to offer to settle the debt. So that's really all it takes is respond to a few questions about your debt, how much you owe, your income, et cetera. And then our software can help you send that offer, negotiate with the collector, and then settle and make sure everything gets documented. So Awesome. Well, Yale, thank you so much for sharing your expertise. Very,
Thank you, Hannah.
very educational tonight. We really appreciate you taking the time to join and help respond to these awesome questions. Thanks everybody for submitting your questions, for listening in, for tuning into the podcast, and also for everyone joining live tonight. Thank you so much for being here and submitting your questions. Before we close, I just wanted to make a quick announcement that currently we are hosting another giveaway at Solo. And it is our Dancing in September giveaway. So I wanted to, for everyone watching live, wanted to kind of share what we're doing. So the Dancing in September debt payoff giveaway is basically Solo's way of helping someone clear their debt. The average amount that people get sued for who use Solo to respond to the lawsuit is $4,700. So in September, we are going to pick a lucky winner to pay off $4,700 towards their debt. And there's no strings attached. Basically, all you have to do is go to solosuit.com/giveaway, fill out this little form. It'll ask you for your name, your email address, your phone number so that we can contact you in case you win, and then your state and the amount of debt that you owe. And you can enter daily to increase your chances of winning the grand prize of $4,700. But it's just our way to give back and try to help someone clear their debt. So for all of those watching live, I'm going to drop the link in the chat. And for anybody listening in tonight, head on over to solosuit.com/giveaway during September to enter for the giveaway. All right. Well, I think that's it. Yale, any last words before we close?
Again, the trick to life, everything in life is communication. So I hope I beat into the heads of all you people on this call and whoever listens to it hereafter. You need to find a way to communicate with a law firm or collection agency that is trying to collect on you. They're not bad people. They're honest. They will help you. All you need to do is communicate. And there's so many different ways to do it. Thank you.
Yep, love that. Thank you, everybody, for listening. If you need to respond to a lawsuit, head on over to solosuit.com. If you want to negotiate and settle, we can also help you do that through our tool called Solo Settle. Yale, thanks again for joining, and thanks, everybody, for listening to